filed one appeal. So kindly recollect that your lordships passed a judgment removing the structure from the railway property just a few days back. Now, lordship, there is a small correction. I have filed an application. It's a factual aspect that the scrap of paper was submitted by the private respondent, not by the state. Only this portion I have, for modification, I have filed an application.
Have you served notice?
Yes, all respondents have affected service. And there is a minor correction in the cost title. It will be Union of India, it will be State of West Bengal. That is separate.
Kindly mark the indicate the portion.
Lordship, I have filed an application.
It will come under the heading to be mentioned. To be mentioned on
Lordship, kindly is an early date because I have filed an appeal. Lordship, this appeal is pending. So, Lordship, I am waiting for this.
Very good. Then on August 29, Friday.
August 29. Yes. Good.
To be mentioned, background for correction.
May please, my lord.
Yes.
My lord, I crave leave to mention one writ petition. This was filed around June 28th, this year, 2025. I wouldn't have mentioned this. This matter pertains to acquisition of land by Mahananda Embankment. Now, the issue is, there was an order from this honorable court that for returning of the land, not even following that order, and they are further acquiring. And in the due process, they have demolished the structure which was already there. And they're continuing. This is a continuing process, which is why I'll show during the time of arguments that there was a valid order from this honorable court, and that was not being followed by Mahananda Embankment authorities. My lord, I know I wouldn't have mentioned this matter following your lordship's direction.
September 3, 2020 under the heading fixed motion.
May I be permitted to mention?
Notice.
I will. And in the meantime, I take this opportunity to convey my congratulations to your lordship. This was long due because I have known your lordship has put in very hard work when he was presiding over court number 11. And I've seen that. And this was long due. Congratulations. Much obliged.
Lordship, may I be permitted to mention a matter for upgradation? The matter is relating to PWD land encroachment. The private respondent are unlawful encroacher who has illegally encroachment upon PWD land in front of the
fixed motion under the heading fixed motion on 8th September.
8th September. Grateful, my lord.
8th September. Serve notice.
Grateful.
Permitted to mention the matter manner for correction. But I am not getting one of its item.
Very good. Is on Friday, next Friday under the heading to be mentioned. Yeah, please indicate the minor corrections on that day. You just give the mentioning slip right now, and on the day of hearing, kindly indicate in the server copy. This Friday. Serve notice. Call the list.
But I am for the petition, the state. On prosecution, they have wrote a letter to me.
Din. বললেন দিন জলপাইগুড়ি থেকে এসে হঠাৎ কি হয়ে গেছে কি আমি বুঝতে পারছি ঘুরে টুরে এসে এখনো এটা কাটছে না the instant matter is listed today under the heading to be mentioned
I'm applying for the petition of my lord, extension of stay order, my lord, kindly see at page.
Who is your other side, sir?
You know, I'm for the response. My lord, there is a direction to file affidavit, my lord. But the affidavit is not ready, my lord.
Paragraph.
Let it be, my lord, extended for a limited period, my lord. In the meantime, we shall file, my lord, the affidavit in opposition.
Paragraph 3 and 4 at page 4, my lord.
You know, ready or not?
No, to extend.
Ashun, at the time what is your full name? Shuddhadev Adho.
I appear for the petition, Honor. The person to process last order lordship, we have already served upon them because since they were not appearing lordship.
Today, my lord, I am ready, my
There's
lord.
relation to file this receipted copy lordship.
On behalf of the respondent number 3, two report have been filed.
Mal.
2 reports have been filed.
Yes.
Mal.
কল্যাণ বাবু তো ভাই আমাকে অর্ডার গুলো আলাদা করে দিন আর এটা একটু আলাদা করে দিন নাহলে খুঁজে পাওয়া খুব মুশকিল হয়
The report filed by way of an affidavit dated 18 July 2023 is the one lordship has I was impugning here.
Give me a second. Sir. Yes.
The matter pertains to lordship a property on the BT Road lordship, earlier known as Ononna Cinema lordship. Ononna Cinema at BT Road lordship in Boranagur. Initial, the three owners of the said property lordship had filed a statement before the ULC authority lordship under urban land selling authorities, and the competent authority under the Urban Land Selling Act had also filed a draft statement. Subsequent lordship, the owners said that it was filed by your mistake lordship and there was no excess vacant land as such.
Who has filed the return?
The draft statement was filed by the competent authority in February 86. But subsequently, the owner said that no, kindly they have filed an application under section 8, raising objection against the draft statement and said that there is no excess vacant land as such in the said property. There is no excess vacant land.
The owner said.
The owner said, yes. The draft statement is at page 154, lordship. Lordship will kindly mark that. It is dated 28th February 1886.
Has it been heard by me earlier? No.
No, lordship. It's for the first time it is appearing before lordship.
So why
It has
there
been
are so
heard at
many?
the end, lordship, by the Austral
Who's my lord?
justice having determination.
Oh, what has happened, my lord?
Be that as it. I am to hear it afresh. Since these flags are there, which is why.
Justice Honorable Royal,
Very good, sir.
Those have
Page
been
number,
marked by-
page number 154.
lordship.
What is that? You are Mr. Laha.
I am Mr. Bandobadal, Suchayan Bandobadal.
What is page number 154, sir?
Lordship. It is at page 154.
The notice.
Annexure P15. It is a draft statement issued by the competent authority under the Urban Land Selling Act.
154 is a notice, sir.
154, lordship. 154.
I'm there at page number 154 of the writ petition.
Yes, lordship.
That is a notice dated 28/2/1986. Kindly check.
Lordship, together with this notice, the draft statement was enclosed there with lordship. Kindly will turn over the page, lordship. The next page is the typed copy of the notice and the 155 onwards draft statement.
Draft statement prepared by the competent authority
Of lands,
lands held by Sri Nirmal Kumar Mukherjee and two
and
others.
two others. Yes, lordship.
So you are referring 155.
155.
Then what is 154, sir?
154 is the notice that was under which notice the draft statement was forwarded.
Give me a second.
Lordship. May I place it, lordship, whereas it appears from records that you and your family members together hold urban lands in excess of provisions made in the Act, whereas on the basis of statement filed by you under section 6(1) of the Act, it is obligated to serve a draft statement under section 8(3) of the said Act. It is therefore ordered that on perusal of the notice and copy of the draft statement, if you require to object to any entry therein, you may submit such objection before the competent authority, Barakpur, against such draft statement within the statutory period of 30 days.
So draft statement has been prepared by the competent authority.
Yes, and forwarded to the owners.
Very good.
Now, lordship, against this, the owners raised an objection under section 8 of the said Act. which is at page 158.
Yes.
So this is the objection raised by the owner under section 8(3) of the Urban Land Ceiling Act, 1976.
Hmm.
Here in Lordship, they first say that we are running a cinema hall, such and such, and Lordship will kindly come to Lordship, the paragraph in the bottom of the page, Lordship, that amongst other conditional requirements of the cinema license, serial number 12 of the schedule attached with it enjoins that the portion of the place licensed shall be occupied or used as hotel boarding or lodging, house, factory, workshop, or manufactory, or for storage purposes, except as the licensing authority allow. Nor shall the place be used for residential purpose by day or night. It is therefore to be observed that in the background of this restrictive provision under the Cinema Regulation Act, we cannot lay our hands which will mutilate the said provision as referred above. And this equally applies to all others, and it will be violative of the Cinema Regulation Act to categorize the carriageway manifestly unjust, unreasonable in the computation of the excess vacant land. The carriageway was being included in the calculation of my vacant land lying in the said property, which was not permissible according to me, because the carriageway was required to be left vacant.
No, this objection pertains to which point of the notice?
That there was no excess vacant land under said act. The draft statement says that I have an excess vacant land of about 247.12 square meters.
Show me the area.
Yes,
Show me that
247.1.
portion.
Yes, Lordship. Lordship will kindly come to page 156.
I am there.
Yes, at the bottom, Lordship, the last column, Lordship, says that extent of vacant land to be
Surrendered.
247.12 square meters.
On this you have objection.
Yes. I say that I have no excess vacant land.
How you explain that?
I explained that by way of Lordship, saying in my objection under section 8, saying that
Place from point number 1, sir. Page 158, point number 1.
page 151. But I am being led by Mr.
Yes, Mr. Kaur.
I should first tell the points, Lord, which are against me before I, Lord, take up the issues. Lord, after the Land Ceiling Act came into force, Lord, the owners filed a Form 6, Lord, written under Section 6. In that, they claimed that they considered that there was some excess vacant land. Now, Lord, based on that Section 6 return, Lord, the notice under Section 8 was issued. In fact, the page that my Lord was seeing, which is at page 156, that is part of, Lord, my return under Section 6.
What is that, sir?
Lord, your Lordships will see page 155. And 156.
Mr. Kaur, that draft statement was prepared by the competent
authority based on my section written under Section 6.
Yes, that is, whereas on the basis of the statement filed by you under
Yes.
Section 6 within bracket 1 of the Act,
Absolutely.
it is obligatory to serve a draft statement under Section 1.
Correct.
That was done.
Yes.
Very
So,
good.
Lord, I must tell your Lordship that when Section 8 draft statement was prepared, it was prepared on the basis of my return under Section 6.
Of course.
Now, Lord, what happens is that I file an objection to Section 8. Now, Lord, when I file the objection to Section 8, your Lordships will find at page 156, apart from Lord, not 156, Lord 157, Lord, apart from Lord taking various points, Lord, we also applied for exemption under section 20. That prayer, your lordships will find in terms of, kindly Lord come to page 159. Kindly Lord see 4.
Yes, clause 4.
Clause 4, sorry, paragraph 4, whatever it is. That in the background of what is stated above and on a realistic approach, sir, you will notice that we have hardly no such land which can be declared as excess vacant land. We have also submitted exemption prayer to the Deputy Secretary Government of West Bengal, HON'BLE land ceiling, etc. Now, my lord, why we said that there was no excess vacant land? Because, my lord, the definition, I'll place the definition of 2Q, which is, my lord, contained in the Urban Land Ceiling Act. Any passage, my lord, leading to the property is not, my lord, taken as a vacant land. Or, my lord, even where the municipal areas which is required to be left out for the purpose of construction, they are also, my lord, not taken as vacant land.
Those are statutory site space.
Statutory site space. And my lord, what happened is that this cinema hall is admittedly was in existence when the 1976 Act came into force. So, my lord, the return which was filed, it was filed by mistake. Now, my lord, what happened is that there was also a prayer made when the return was filed, also a prayer made for exemption under section 20. If there is a vacant land under section 20, the authority had power to exempt, Lord, that vacant land and permit holding of that excess vacant land. Now, my lord, here what happened was, before adjudication under section 8, and Lord, my representation, the authorities, Lord, passed an order under section 20, subsection 1. Your lordships will find that at page 168. This order was passed on 20th of February 1996.
Mr. Court, do you think that what is your contention in page number 150 in your objection rather?
Yes.
Those are not required to be looked into for the disposal
For
of
the disposal, for the time being, your lordship need not, Lord, look into it. Because, Lord, there is an order which I'll place of the Joint Secretary, where the Joint Secretary had said that this has to be reassessed.
So, page number 168 is the reasoned order based on the on your objection.
On my, Lord, prayer for exemption. Exemption under 20, section 20.
No, that is the part and parcel of the objection.
No, part and parcel of the objection was that there is no excess vacant land under section 8. Lord, may I just get back to that objection first? I'll let me, Lord, place the objection.
So you have separately filed an application for exemption.
Separately.
What is that?
Lord,
that has not been annexed.
No, that is not here.
Very good.
That
anyway,
so, Lord, before, Lord, adjudication under section 8, this order was passed under section 20.
So, Mr. Kaur, let me have a chronology.
Yes.
You have submitted a return under section 6.
Yes.
They have submitted. They have served a notice under section 8.
Yes.
Along with the statement.
Yes.
Against which you have raised objection.
Correct.
Thereafter, you made a prayer for exemption.
I made a prayer for exemption when I filed the return under section 6.
Very good.
So
you also prayed and prayer for made an exemption upon which this reason order was passed. Very good, sir. I understand.
This order was passed only, Lord, relating to 20, exemption under 20, not, Lord, objection under section 8.
Yes, sir.
Now, Lord, what happens is, kindly see this order. I'll just place the operative part of the order. Now, therefore, in exercise of the power, etc., Section 20 of the Urban Land Ceiling Act, the governor is pleased hereby to exempt the said vacant land as described in the schedule below from the provisions of Chapter 3 of the said Act, subject to statutory clearance from all concerned authorities as etc. to the following conditions.
So, exemption was granted.
Exemption was granted. Kindly see 2 and 3. No construction can be made on the exempted vacant land. It is to be kept
No construction can be made on the excess vacant land.
excess vacant land. And
It
Lord,
is
the
to be-
excess
it is to be kept
perpetually vacant.
perpetually vacant. Very
Your
good.
Lordships will kindly see the extent of vacant land and the first paragraph itself. 369.79 meters, square meters.
Where from will get it, sir?
At the first line, whereas Nilmoni Mukherjee so and so is jointly holding vacant land measuring 369.79 square meters.
Yes.
Described in the schedule below, which is in excess of the ceiling limit referred to in clause A of subsection 1 so and so.
Then what happened, sir?
Then what happened is, Lord, kindly see 167. The owner said that complete the adjudication. Your Lordships may kindly come to page 167. The date is 2nd April 1996. This has reference to the letter number such and such, A Xerox copy is enclosed. We have noted the contents of the above order, which was obviously issued in the context of particulars furnished by us to substantiate the fact that we do not possess no such land that can be declared as excess vacant land, and as originally earmarked in the draft statement in relation to the case number such and such forming a part of the stated draft statement. Under the above circumstances, the final statement may kindly be available to us as quickly as possible. Now, Lord, if your Lordships kindly see the scheme of the Urban Land Ceiling Act once. Sorry.
This letter was issued in respect of which letter?
My application for exemption. Your Lordship is no, this page 167, your Lordship is
Yes.
asking. In respect of the proceedings under section 8.
Achha.
In respect of proceedings under section 8. Lord, I feel it is my my own problem. Lord, I should have prepared a complete list of dates, because all this confusion that is arising is because of the Lord, there are two different parallel proceedings. One is section 6. I file a return. One is an application for exemption, which I file under section 20. Now, Lord, so far as section 6 is concerned, it proceeds like, first, Lord, a draft statement, then, Lord, a reply, and then, Lord, final statement in terms of section 9, and then, Lord, ultimately a publication under section 10. Section 20 was an exemption which was allowed by the government immediately after my application was filed. Government immediately allowed that section 20. So, Lord, there were no issues in respect of section 20. The issue was the completion of the proceedings and, Lord, the order of vesting to be passed in the proceedings. Because, Lord, one is exemption which is allowed on my representation without there being an actual proceedings drawn up for the purpose of vesting. Now, Lord, all the subsequent, once we receive that exemption, all the subsequent proceedings are in relation to the vesting. Now, my lord, your lordships may kindly have a look at the scheme of the Urban Land Ceiling Act once, just for 2 minutes, because this will no, Urban Land. একটু দেবেন judge. Yeah. Lord, please come to section 6 first.
Yes.
Lord, it says every person holding vacant land in excess of the ceiling limit at the commencement of this act shall, within such period as may be prescribed, file a statement before the competent authority having jurisdiction specifying the location, extent, value, and such other particulars as may be prescribed of all vacant lands and of any other land on which there is a building, whether or not with a dwelling unit therein, held by him, including the nature of his right title interest, and also specifying the vacant lands within the ceiling limit which he desires to retain. Provided that in relation to any state to which this act applies in the first instance, the provisions of this subsection shall have effect as if for the words every person holding vacant land in excess of the ceiling limit at the commencement of this act, the words, figures, and letters every person who held vacant land in excess of the ceiling limit on or after 17th of February 1975 and before commencement of this act, and every person holding vacant land in excess of the ceiling limit at such commencement had been substituted. Then, Lord, explanation, I'm not really, Lord, at this stage, your Lordship need not, Lord, go into section 6 because there is no dispute to the fact that a return was filed. Now, Lord, please come to section 7 and then, Lord, just glance over section 7, which is not applicable in so far as the petitioners are concerned. That in so far as section 7 is concerned, it talks about filing of statement in cases where land held by a person is situated within the jurisdiction of 2 or more competent authorities. Here, it does not apply so far as we are concerned. Come to section 8. It says, on the basis of the statement filed under section 6, and after such enquiry as the competent authority may deem fit, to make the competent authority shall prepare a draft statement in respect of the persons who has filed the statement under section 6. Then every statement prepared, this is the draft statement. Lord, then kindly come to section 9. This is the final statement. Because on the draft statement, Lord, there is a provision of objection and, Lord, hearing the objection. And then, Lord, it preparing the draft statement, it says, after disposal of the objection, if any, received under subsection 4 of section 8, the competent authority shall make the necessary alteration in the draft statement in accordance with the orders passed on the objections aforesaid and shall determine the vacant land held by person concerned in excess of the ceiling limit and cause a copy of the draft statement so altered to be served upon the manner under section 3 of subsection 8, etc. Now, Lord, if your lordships now come back to the page 167, your lordships will find that the owners were saying that please issue a final statement. It says this has reference to a letter, etc. And we have noted the contents of the above order, which was obviously issued in the context of the particulars furnished by us to substantiate the facts that we do not possess no such land that can be declared as excess vacant land as originally earmarked, etc. Under the above circumstances, the final statement may kindly be available to us as quickly as possible.
So, according to you, Mr. Kaur, after filing of the objection, as a copy of which is available at page number 158 and 159,
yes,
no file order was passed. So, practically, it is an issue, it's a reminder.
Absolutely. It is a reminder that please give us a final statement so that, Lord, the matter can proceed further, because while on this act, if your lordships will not kindly take section 10 also.
Yes, sir.
It says, as soon as may be after the service of the statement under section 9, on the person concerned, the competent authority shall cause a notification giving the particulars of the vacant land held by such person in excess of the ceiling limit and stating that such vacant land to be acquired, the claim of all persons interested in the vacant land may be made by them personally. Then 2, after considering the claim of the persons interested in the vacant land made to the competent authority in pursuance of the notification published under subsection 1, the competent authority shall determine the nature and extent of such claims and pass such orders as it deems fit. Then 3, at any time after publication of the notification under subsection 1, the competent authority may, by notification published in the official gazette of the state concerned, declare that the excess vacant land referred to in the notification published under subsection 1 shall, with effect from such date as may be specified in the declaration, be deemed to have been acquired by the state government, and upon the publication of such declaration, such land shall be deemed to have vested absolutely. So, my lord, we did not reach up to this stage. We did not reach up to section 9 also. But, my lord, what happened is, the state government exercised power under section 20. If your lordships now kindly have a look at section 20. May I please section 20, my lord? May I please?
I'm there, sir.
I'm sorry. Notwithstanding anything contained in any of the foregoing provisions of this chapter, when any person holds vacant land in excess of the ceiling limit and the state government is satisfied either on its own motion or otherwise that having regard to the location of such land, the purpose for which such land is being proposed to be used, and such other relevant factors as the circumstances of the case may require, it is necessary or expedient in the public interest so to do, that government may by order exempt, subject to such conditions if any, as may be specified in the order, such vacant land from the provisions of this chapter. Where any person holds vacant land in excess of the ceiling limit and the state government either on its own motion or otherwise is satisfied that the application of the provisions of this chapter would cause undue hardship to such person, the government may by order exempt such, subject to such condition as if any, as may be specified in the order, such vacant land from the provisions of this chapter, provided that no order under this clause shall be made unless the reasons for doing so are recorded in the right.
So, Mr. Kaur, would it be correct to say that section 28 postulates that even if the state government is satisfied that it is an excess land,
Yes.
but by
It can allow.
exercising this power, it may exempt and there will be no vesting.
That land cannot be vested. That land, if once, Lord, unless there is an ascertainment that I am holding a excess land, this 20 will not come into play. Because, Lord, 20 presupposes that there is an excess vacant land which is being held by me. Lord,
section 20 presupposes excess land.
Excess land.
Possession of excess land.
Possession of
because
excess.
where any person holds vacant land in excess of the ceiling limit and the state government is satisfied either on its own motion or otherwise that having regard to the location such and such, the purpose of proposed to be used government. So, in order to exercise the power of exemption, the government has to come to a finding. Yes, that person holds an excess land, and however, that land is not required to be vested. Other since it would cause hardship to the holder of the owner of the land.
Lord, the grievance of the owners are that, Lord, the proceedings for vesting has not been completed as yet. The proceedings for vesting starting from 8, 9 and 10, that proceedings have not been completed. On the basis of the prayer of the owner, that was allowed. The section 20 application was allowed on the basis of the prayer of the owner. But Lord, today the exercise that is required by the statute has not been done. Now, Lord, what happens after this is more interesting. Your Lordships may kindly straight away, the Lordship has seen the letter at page 167. Then, Lord, what happened is the page 171 kindly come to.
You are the owner of the property.
Yes, Lord, I am the owner of the property. There has been a transfer of the ownership in favor of the present
petitioners.
Present rate petitioner. They need
From Mukherjee to
this
Singh.
the Mukherjee to this company.
So, Mr. Kaur, if I look to page number 167 and 168 conjointly,
Yes.
167 presupposes that there was no adjudication under section 8. Am I correct? So if there be no adjudication, according to you, page number 168 cannot be issued.
No, 168 Lord was issued on the basis of my prayer without Lord the adjudication being complete.
Achha.
Lord, I had applied that because Lord I had filed a section 6 a statement under section 6. I had also applied
I
for,
understand, sir.
but Lord that application ought to have been taken up after Lord the completion of the proceedings.
Very good, I understand. Then on the basis of your application 6, 7, 8, the authority ought to have come to a finding
Up to
that
10.
you are in possession of the excess land.
Correct.
And then only they can apply the power of their under section
20.
20.
But Lord 20 was granted. Now what happened
So
was
how it is going to prejudice you?
no, it will not. But Lord, the proceedings must come to a conclusion in accordance with law. What they are doing is, Lord, now they are trying to implement 20. They are proceeding on the basis that 20 has become final. And Lord, they are taking steps in terms of section 22. Now, Lord, this is what the grievance in this writ petition is. Just give him, Lord, 5 more
Yes,
minutes.
yes, take your time.
Just 5 more minutes because I have to explain. There is so much of facts involved. I will have to.
Yeah, rightly, if you have make a list of date, it would be easier. Anyway, you please start.
Lord, only thing is, if it is not inconvenient, Lord, could it be fixed on at 2 p.m. Lord any day? Because this is a hearing matter.
Absolutely, I was also under impression that why it is in the listed under the heading motion.
Maybe Lord, I don't know.
It is my order.
Because during the morning session, Lord, I'll be.
As a matter of fact, I was following the order of the coordinate bench.
Yeah, what had
The
happened?
coordinate bench on 15/1/2025 matter to appear under the heading motion land matters.
Lord,
It should be a hearing matter.
This is a hearing matter. I must be candid to your lordship.
Absolutely.
And Lord, they have filed a report, Lord, in the form of an affidavit. The earlier, in terms of the earlier order. But if your lordship, Lord, kindly permits, Lord, on a Friday or whichever day at 2 o'clock, Lord, if your lordship kindly fixes this matter. It's
Very
point
good.
is very
I can
interesting.
fix it on Friday.
Point is very interesting. If your lordship, Lord, kindly.
Heard Mr. Kaur Lanet, senior advocate, appearing on behalf of the senior advocate. Yes, call the next matter.
Number 4.
Item number
My lord,
prime for the
petitioner, my lord, led by Mr. Arindam Das. My lord, his wife is admitted in the hospital, my lord, due to not able to come. I am only praying for only not today, my lord.
today, yesterday,
Name, sir?
Noni Gopal Chakraborty. I am for the Union of India. Just yesterday, I have received this a voluminous brief, my lord. And it takes it.
Who is the answering respondent?
As a state is the National Highway Authority.
6, 5,
5, 6,
5, 6, 5 and 6.
5 and 6.
5 and 6.
Competent authority land acquisition.
You are for the 5 and 6?
No, no,
No, it's my junior. Union of India. And kindly takes up next week in Revenue. Just yesterday I have received this week, my lord. I have
On behalf of the on behalf Respond number 6 is your client. Respond number 6 and 7. Kindly check, sir.
Respondent number 6.
Chief Engineer, National Highway, PWD roads director. PWD.
See,
চারটা করতে দে তারপর পাঁচটা করবি আগে চারটা করতে
you are for 4. Just a minute. You are for 2 also. 2. You are referring item number which one?
Lordship, in item number 4, Lordship.
4
In item number 4, Lordship, we are appearing for
Item number 4. Wait. Item number 4 is WPA 8301 of 2025.
Yes.
8301 of 2025.
You who is for the petitioner?
Yes.
You are for the petitioner. Very good. You are for the Union of India. Union of India. And you are appearing on behalf of?
Respondent.
Tell me who are the respondents? Who are your clients?
Item number 4, we are appearing for 2,
Yes.
3, 4. National Highway, we will not appear. 2, 3, 4.
6
2 হচ্ছে land and
চার
secretary.
চার এটা
2, 3, 4. National Highway আমরা নয়, 5, 6 not. 7 or 9. So 2, 3, 4
Eight,
and
nine.
8, 9.
2, 3, 4,
8, 9.
6
8 and 9. The kindly come to respond number 5. Cost title. The competent authority
Land-
for land acquisition under National Highways Act
Lordship,
Yes.
yes. Land acquisition, we are appearing for land acquisition. But
Then why are you not saying?
highway,
No, no.
national highway we are not.
আরে ওটা আলাদা
For plan 5.
You don't know who are your clients.
Yes, 5.
And you are, who is for the respondent number 6 and 7?
6 is the Lordship Chief
Chief Engineer, National Highway, PWD
National
Roads,
Highway. This is of National Highway.
আরে গভর্নমেন্ট অফ ওয়েস্ট বেঙ্গল
Government of West Bengal.
PWD is there. PWD is there.
Six,
Lordship, then
seven,
we
eight.
are appearing, Lordship.
আপনি কি পিডব্লিউডি হয়ে অ্যাপিয়ার করছেন? হ্যাঁ
And then 7,
একই
7 catch. Executive Engineer, National Highways.
এই তো
PWD Roads.
PW, Lordship. From 2 to all. 2 to 9.
নিজেরাই জানেন না কোনটা বুঝতে পারছেন না। তাহলে সবাই অ্যাপিয়ার করে গেল তাহলে।
প্রচুর মামলা
So National Highway Authority is not the party. Very good. আসুন। The only 4. Tell me. Why not 2? No, sir. I'm talking about WP 8307. Huh? Is the Principal Secretary Department of the Land and Reforms Department. কি বলছেন গো তুমি বুঝে উঠতে পারছি না হ্যাঁ 8307 কি দেখান কি বুঝতে পারছেন না নিশ্চয় দেখি বলছে 2, 3, 4, 5, 6. What are you doing, Mr. Dey? Huh? In the morning? Lego. ওই তাহলে সেম অর্ডার করে দাও সেম অর্ডার monthly September under the heading fixed motion. Yes, call the next matter.
I'm for the petitioner, my lord. I'm for the private respondent. Chalo.
It's for the petitioner.
Well, the property has been enclosed the
Give
same.
me a second. Service has been affected upon all the respondents.
Yes,
Who is for the private respondent?
I am for the private.
4 to 8. Mr. Bandyopadhyay is for the read petitioner. Yes.
For the state.
I'm sorry, for the state. Yes, sir, please.
My lord, 4 to 8. Here, my lord, 4, 2, 3, 4, 6. Kindly. Petition which has been served upon me, my lord. Number is, my lord, 4, 2, 3, 4, 6.
Be there as you are appearing in front of the respondent. Very good. Then raise your case, sir.
4, 2, 4, 5.
Sir, my land is Dag number 1072 is my land and annexer P1, my lord. And encroach the PWD
1072.
yes, my lord.
Danga. It is standing in the name of Parvez Mehdi.
Parvez Mehdi.
Parvez Mehdi is the read petitioner.
Yes, my lord.
What happened to you?
Encroach the PWD
Encroach the PW means?
land.
Who?
Private private respondent is illegal construction, and my land is encroached the PWD.
Who has encroached your land?
PWD.
PWD has encroached your land.
Yes.
Well,
And-
allegation against the private
Private
respondent.
respondent. Also
They
private.
have encroached the petitioner just in front of the petitioner's land, encroaching the PWD land that should be removed. He made representation before the authority that is pending.
For last 50 years, my lord, we are residing in the same land, my lord. My lord, Panchayat tax has been, my lord, paying against the said land. My lord, I can show some documents, my lord. Allow me, my lord, to file a affidavit, my lord.
The letter has been issued by the assistant engineer. to the
My lord, kindly allow me to file a supplement, my affidavit in opposition, my lord, against the writ petition, my lord. My lord, I can, my lord, some documents have been handed over to me, my lord, where, my lord, I have been paying the, my lord, Panchayat taxes and other taxes, my lord, against the said land matter, where, my lord, I am
Do you have the title?
staying for last 50 years, my lord.
Unauthorized document.
The affidavit of service has filed today on
Lordship, I'm praying for not today, Lordship.
Why? Who is praying for not today?
Why?
Why?
Mr. Dhar is on his legs, Lordship. He's up for the respondent.
Madam,
Private respondent.
I am
my
not
lord.
in this
something has
matter,
to be
Lordship.
done. Who is the junior advocate?
She is out of station.
My lord, she there for the state, my lord. I am appearing for the private respondent. Here, my lord, the issue is this writ petition is not maintainable. One second, I will just indicate it is not
No, I
maintainable.
will not hear you.
The reason
What is the case, Mr. Chakraborty?
My lord, the case, my lord, give me 2 minutes, my lord. Yes, some facts have to be canvassed, my lord. First of all, on 13 September 2021, in a writ petition WPA 3998 of 2021, my lord, this court, the Honorable Court had directed Assistant Jurisdictional Assistant Engineer to complete proceedings initiated in respect of encroachment in plot number 38 of the concerned Mosa. Now, my lord, in that writ petition, tell us sorry, my lord, this aforesaid order of 13 September, my lord, it culminated in an order passed by District Magistrate on 22nd February 2022, directing that all encroachment in plot number 38 must be removed.
In a proceeding under 10-4.
10-4. It was ordered that all encroachment in plot number 38 must be removed. Now, my lord.
So the private respondent of the instant writ petition, the appellant before there.
Yes, yes.
Then why you have filed the writ petition?
My lord. In our WPA 22593 was preferred by the private respondents hearing. In that writ petition, my lord, the private respondents hearing had stated that there is illegal encroachment in plot numbers 38 and 380.
At your instance?
No, at their instance, the writ petition was preferred. In 318, my lord, I have certain shop rooms. So in writ petition of 22593, the Honorable Justice Shubhra Ghosh had directed that since encroachment in plot number 38 has already been taken care of in the previous writ petition, in respect of 318 may be initiated subject to representations being made and reasoned orders being passed upon opportunity of hearing. Now, my lord, the assistant engineer passed an order of demolition. Now, my lord, there was direction that I should be heard before the order is passed by the assistant engineer in writ petition 22593. That was not done. Order of demolition was passed. Now, thereafter,
Without hearing you?
Without hearing. The order of demolition was served upon me, but then I was not heard before passing of that order. Now, then it went up in 10-3.
No, notice was served.
Notice of demolition to vacate the property was served.
Then why have not appeared?
No, my lord, I was already directed to vacate. I was not heard prior to the notice being passed, because a direction was passed by the Honorable Court in 22,593 that you must hear all concerned parties before taking any action. So, my lord, kindly comes to page 62.
Give me a second, Mr. Chakraborty.
Yes.
Page number?
And it kindly comes to page 61. That is the writ petition preferred by the private respondents. Yes. The operative part, my lord, kindly comes to page 63.
Give me a second.
Sorry.
Yes.
Kindly comes to page 62, the operative part of the order.
Fourth respondent is directed to consider and dispose of the representation within a period of 3 months from the date of
granting opportunity of hearing. This was not given to me. 10-1, my lord. At the time of 10-1, my lord, I was not heard. It was not. None of my objections were taken on record. Yes. Thereafter, it was taken up before the SDO. Under 10-2, it was transferred to the SDO. 10-3, the SDO passed an order.
Just a minute, sir. 10-1 postulates service of notice.
Yes, madam. But the
If
court,
the requisition of the notice is not complied with, then 10-2 comes.
yes.
Such and such highway authority such and such may make an application to the executive magistrate for removal of the encroachment. So in 10-2 proceeding, order is passed under section 10-3.
Yes. 10-3 order
And
was
if
passed.
10-3 is, if you are aggrieved with the 10-3, you have to approach
10-4.
the district 10-4.
Yes.
Now tell me what is your grievance?
My grievance is the court had directed the fourth respondent, the assistant engineer, to hear me
Huh?
a reasonable opportunity to dispose of the representation after granting reasonable opportunity of hearing to all interested persons. I was not heard. but I
So
was
without,
told
so representation submitted by them,
yes, my lord, but I am
representation submitted by them.
yes,
So at the time of disposal of the representation
I was not heard.
and prior to issuance of 10-1 notice, you are not heard.
No. And
How
as
do you
man-
substantiate that?
My lord, I
How do you
substantiate. I have pleaded it that I was
Pleaded
not
it?
heard. Yes.
Uh,
Kindly comes to my lord paragraph.
where is your pleading to that effect?
My lord. Okay. Sorry. Yes, kindly comes to paragraph 14, my lord. Page 8 of the writ petition.
Yes.
Your petitioners further submit that thereafter said assistant engineer contacts highway subdivision passed an order to demolish construction without granting an opportunity of hearing to them, also violating the order passed by the honorable court. No copy of notices of no notices were served upon the petitioner. It was mandated by the court in the writ petition while disposing of the writ petition.
Where is the order of 10-3 proceeding?
10-3 proceedings.
Show me the 10-3 proceeding.
Yes. It is at page 89, madam.
Page 89.
Yes. Page 89, 25th March 2025. And perhaps the date is not really clear.
25th March 2025.
Yes. Page 89.
I have got it. Give me a second.
Yes, madam.
And what is the order of the 10? What is the order of 10?
107, madam.
Yes, what have you got to say?
But in the meantime, Mallard will also see that from the first order, the order where they indicate that they were not heard, no opportunity was given. If Mallard goes
What
up,
on your, while disposing your representation?
Mallard, they were present, they were heard. Thereafter, they filed an appeal. The appeal got rejected. In the
That's all
mean,
right.
Mallard, that is always there in the same page, Mallard, page 88. If Mallard comes to
Page 88.
yes, my lord. The order starts at page 88. My lord, we'll see 5th of September 2024. Petitioner filed Hazira, cases put up
No,
for
sir.
hearing.
Page 88 onwards are the orders passed in a 10th proceeding.
In the 10th proceedings. So, my lord, first,
No, Mr. Chakravarti's grievance is that you have submitted a representation before
my
the
lord,
assistant engineer.
my lord,
You are aggrieved that your representation has not been disposed of.
my lord,
The coordinate being directed for disposal of your
my
representation
lord,
after hearing both sides. At that stage, Mr. Chakravarti's clients was not heard.
Yes.
It is his grievance.
my lord, at that stage, this is in terms of the order of Justice Shubhra Ghosh, which was passed in WPA 22593 of 2024, which my learned friend has pointed out the first instance of the order. My lord will take page 88. My lord will see that this particular proceedings has been initiated in respect of the same order,
Sir, I
same
understand.
direction.
Mr.
And my lord,
Chakravarti,
before this,
have you annexed the order of the assistant engineer?
No, ma'am.
Then
Not annexed to the reputation. I must confess.
all that is there. These are there. Thereafter, he has gone up. He has waived that.
To clarify, after the 22,593 repetition order was given by Justice Ghosh, my lord, an appeal was preferred by one
Take
of the
down.
petitioners.
recent order passed by the assistant engineer while disposing your representation. That is your
There
case.
is two issues, my lord. After my first order was passed, I will just indicate one thing.
Sir,
After
don't indicate anything.
after
Try
the,
to answer to my question. Are you in possession to
I'm not in possession,
substantiate
my lord.
that while passing the recent order on your representation, they were heard? Have you got the order?
May I just I have, my lord, may I indicate two more facts, my lord, before I come to that. The reason being, after this order was passed of Justice Ghosh, my lord, there were two other writ petitions filed with regard to the issue that these,
Take down.
my lord, the representation was not considered.
Listen to my order.
No, my lord, will kindly give me 1 minute's time. This matter has then traveled to the issue with regard to whether it has been this he was not heard.
Sir,
That
just
issue
show me
has
the
been waived.
document. Show me the
My lord
document
will first
that
see.
while passing the recent order on your representation, they were heard. I will make sure that the repetitioner will be thrown out of the court.
Well, I may not have a copy right now, but I will just arrange for it.
Well-
The reason being, my lord, even I was not prepared that he will take this particular issue. The reason, my lord, he has filed an appeal
Repetitioner.
on from in respect of tag number 38 and 138, it was initially filed as a writ. It was converted as a PIL. In that PIL, the Chief Justice directed the fifth respondent in that writ petition to again consider the representation. And even on that score, my lord, there is an order of
There is no coordination between the learned senior advocate and the advocate junior advocate. Madam, I am sharing this experience. Since I very unfortunate state of affairs.
For the statement. Item number 8, the private respondent who has encroached the plot of 468 by 940.
Give me a second, sir.
এটা আগের অ্যাফিডেভিট সার্ভিসটা আগে দিয়ে গেল।
Yes, Mr. Mukherjee.
But what happened, Malad? That Malad, in Uluberia.
এগুলো কি দিচ্ছেন? You are for state.
I am for the state. One is affidavit service. Thereafter, when I mentioned the matter pleading the urgency, I have served upon the state as well.
Is there any private respondent, sir?
Private respondent also served.
Service has been affected?
Yes, ma'am. A lawyer appeared whom I have also served. Now, kindly straightway come to page 11. Page 11, kindly see. But your lordship will find that it is a government land, Khotia number 1. And in the top Khotia number 1. Now, kindly see the plot number 468 by 940. In this particular plot of land, the private respondent
made illegal construction.
No, not only that, but kindly see 466, that is Hashpatal, page 11. 466 Hashpatal, 468 by 940, Danga. In these two plots are government land. One is one hospital in Uluberia, that is the only hospital for the local people. In both the plots, private respondent are making construction and encroaching the government land, over the government land.
How you are agreed?
We first of all, we can't enter the hospital because in the front portion, I have kindly see paragraph 8. Because when we are trying to enter the hospital, they are making construction. They are the building materials are there. Ambulance cannot go. Second thing, the second plot, for that the egress and ingress of the petitioner and the villagers have been totally been blocked. Now, for that reason, I made a representation. Now, on the basis of the representation,
along with your family members are facing inconvenience, other people are also facing the same problem. Very good, sir. What is your representation?
Now, on the basis of representation, first I have given, kindly see page 12. Because there is no permission from the Howrah Jila Parishad in the government land. Second, CMOH because the hospital. Then, assistant engineer, Uluberia PWD.
Page
18. Then page 23 is the district magistrate. No, 62 acted. No, he's a acted. Another document that highway acted mom. Highways PW land. Highways PWD land. All I can PWD already notice DH. And on the basis of the same the public PWD assistant engineer already direct the BLRO for demarcation.
Demarcation report obtained.
Kindly see page 27, that has been forwarded to us. But the first type copy is my 27A. Demarcation of government land adjoining to Shankarhati Primary Health Center. The public works.
BLRO submitted report.
Yes, my lord.
Where is the report?
Encroachment proved.
Where is the report, sir?
Yes, my lord. I have already submitted my lord report.
Construction is going on.
My lord, and from on that report, my lord, kindly come to the page number 9, annexure E, my lord.
Three point five already, my lord, they have found, and next date has been given, my lord. Let them conclude the proceedings, my lord.
So joint demarcation program is still on. The joint demarcation report has not yet been submitted.
Not yet been submitted.
My kindly see, my lord, once, my lord, I have been forwarded a copy, my lord, kindly see, my lord, 12 June 2025 memo.
Just a minute, sir. What is the annexure D?
Before annexure D, if you let me see annexure.
I'll see, sir. I'll see.
I'm sorry.
So you have the revenue inspector noticed 3.5 width, 0.5 width encroachment. Recording of Poschimo such and such. Then what happened?
Then kindly see annexure E.
Annexure E.
12 June 2025.
Yes.
Already BLRO informed the same.
Annexure E, sir. Was conducted and 3.5 was encroached.
Yes. Then my lord, annexure F. This my lord, Assistant Engineer Uluvadia Subdivision Public Works Department asks the BLRO, and everything has been forwarded, my lord, your lordship will before the district magistrate, my lord.
Joint demarcation program is needed adjoining to.
Again,
so when you have notice that there is a encroachment, why there is a joint demarcation report program?
Now kindly see
When your revenue inspector noticed 3.5 meter, 3.5 feet encroachment over LR plot number 460 of 940, then why there is necessity of joint demarcation program?
it is required because my lord, PWD officer engineer was absent on that day. Kindly see, my lord, once my lord, the document has been forwarded to me. Now my lord, the BLRO forwarded the same before the additional district magistrate.
Page?
Page, my lord, 13, my lord. Kindly see the last paragraph. Revenue Inspector Sakrail 1 reached the spot on 17/7/25. No representative from the end of PWD Uluvadia subdivision appeared to conduct the joint inquiry. Therefore, for that reason, again, my lord, date has been fixed, my lord. Kindly direct them to conclude the proceedings, my lord. Last date is on 13th August, my lord, page 15. Kindly see.
Page number 15.
15, my lord. After that, what happened, I don't know, my lord. In the meantime, they are hurrying.
No, it is the 20th August.
20th August, my lord. What happened in the plot, my lord?
I'm passing.
আসুন
Unconditional apology. Today, our matter is fixed as item number 9. The Lordship has fixed it by considering its grand urgency, Your Lordship. Your Lordship, the urgency is that by tomorrow, 12 o'clock, the respondent authority is going to dispose me from my dwelling house. Kindly fix this matter today, Your Lordship.
No.
Both
Sorry,
the
not
other sides are present, Your Lordship.
Sorry, not possible. Call the matter list.
Your Lordship, the matter is fixed today, Your Lordship, as item number 9, Your Lordship. Please consider. I beg with Your Lordship.
Yeah, I'm not supposed to take up the hearing matters now.
Then, my Lord, kindly fixed tomorrow, Your Lordship, the first sitting of the court.
It will be to automatically come tomorrow. Item number 8. Let the file be placed first. All are analogous.
Lordship?
All
Yes,
are
analogous.
When the order of tagging was passed?
That, my lord, I only have orders from 2019. That must have been with the
Is there any formal order regarding tagging?
that, my lord, I have to check up. I find there is an order of this is not an order of tagging really. This is an order of December 12, 2019. In fact, my lord, there were 4 matters appearing together.
2019.
2019. This is not really an order of tagging. This only says there's a substantially similar.
Then how tagging has been done?
I have to, my lord, then find out.
Stand adjourned after opening of the Hetu.
Chapter. Okay.
Give me a second, sir.
Yes.
Kulano.
Come on.
On 12th December 2019,
Lordship.
the order was passed.
Lordship.
Thereafter,
Yes.
on 29/3,
yes,
an order was passed where the cause title indicates tagging of all cases.
Yes. Now, may I, my lord, indicate one thing? There were, my lord, 4 writ petitions filed, one after another. Now, 3 are before your lordships. Now, the 4th matter
or rather the first matter probably. That matter was similar facts, but what happened is post-COVID, that writ petitioner passed away. So that has not been pursued. We took instruction and the other not there willing to pursue. Only order I can find in that fourth matter from my records. This is not really an order of tagging, only this is the fourth matter which is not before your lordship because it has not been pursued since the writ petitioner passed away. Only this I can find right now, but I can of course try to find out from.
Without any formal order of tagging, orders are going to be passed.
Yes, yes, I
Mechanical.
bow down.
No, there's no tagging. These matters are similar.
Similar.
Similar prayer are there.
Similar.
The writ petitioners are different.
Different. Writ petition is different.
It is the same, prayers are same.
Effective respondent IIT Kharagpur, but it's
very good. Place your case. Pleadings are complete.
Yes, yes. Pleadings are complete.
In all the matters.
Yes. In fact, my lord, defenses are also similar. So
yes, replies there.
Yes.
Very good. Place your
my lord, before taking my lord to the documents,
Hmm.
may I lord indicate as to what has happened in this matter, what is my grievance and what is the defense, so that my lord, we know which documents my lord we need to look at. Now, may my lord proceed?
Please, sir.
Yes. Now, the writ petitioner in WP 33771 of 2014, Praloy Kumar Sengupta, was my lord employed as a lower division clerk with IIT Kharagpur.
Yes.
Now, my lord, at that time, my lord, he was governed by the scheme of CPF, Contributory Provident Fund, cum gratuity.
Yes.
Now, lordship would find there are also, my lord, in between other files, but what is important is sometime around 1997, lordship would find. I will, my lord, take my lord to records. I am just indicating what has happened. Technology.
No, I'm noting the case number only.
Oh, lordship. Lordship.
So be rest assured that I'm not writing anything
Lordship.
against you.
No, no, no.
You're Mr.
Sharathi Dashgupta.
Yes, Mr. Das.
Yes. Now, my lord, 5 minutes lordship before I go to the documents. Now, yes, in 19.
You are appearing on behalf of IIT.
In 1976, I was appointed. Now,
as a lower division clerk.
As a lower division clerk. There is no dispute about those parts. Dispute is actually very limited. Now, in around 86, 87, the fourth pay commission came in. Now, one office order came in that those who want to continue in CPF, they should exercise that option. I exercised that option. I said, yes, I want to continue in CPF, not in GPF. No dispute there. Around 1997, effect of fifth pay commission. Now, I was given an option, all the employees are given an option that if you want to again convert to GPF, please exercise your option. According to me, I would say, I exercise that option. But fact of the matter is, I cannot show
the option for GPF.
For CPF to GPF conversion. This is 97.
Yes.
Now, fact of the matter is, I cannot show anything from records that yes, I had in fact exercised this option. This is my statement in the writ petition that is there. And they have said, no, there is nothing on record. It's true. Now, in 2010, I retired in 2011, just to. Now, in 2010, what happened is, pursuant to the sixth pay commission, where the dispute really starts, again, my lord, an office memorandum was, my lord, taken out, where the IIT Kharagpur, the authority stated this. There are, my lord, two limbs to the memorandum. I will show that.
One is those employees who had given the option previously in 97 for CPF to GPF, but for some administrative lapse it could not be done. Their case would be considered. This is the first limb, and they have to also, my lord, show that they had in fact exercised that option, but I could not show. That is a fact. The second limb, which is more important for my case, is that even other than those employees, the others, if they want to exercise this option from CPF to GPF, they also, their case would be considered. These are the two limbs. This is in 2010. I can show from records, I will show, my lord, that this time I exercised this option. I said that
in the year 2010.
In 2010, I said, yes, I want to also change. In the support of the fact, because this would assume significance in view of the defense, in support of the fact that, yes, in fact, in 2010, I had exercised such option, I have also annexed copy of the register maintained by the concerned department, accounts department of the IIT Kharagpur, showing that on such and such date, 2000, I believe August 23, 2000 or something, I'll show that a letter has been received from Pralay Shyama Sengupta, petitioner of your lordship, the registered usual practice. This is in 2010. 2011, I retired, nothing done. Now, what is curious is this memorandum, which came into effect in 2010, this was given effect to with effect from 31st December, post 31st December 2012. 2010, 11, 12. Now we are in 12.
Memorandum was published in the year 2010.
But ultimately effect was given post 31st December 2012. Now, lordship might ask me, why is this significant? The significance is this. Now, post 31st December 2012, I came to know that, yes, this has been done.
You retired in the year 2011.
2011, I have retired. I am not disputing that at the time of retirement, I was treated as CPF. I also took my benefits. There is no point in disputing those things. It is fact. But the fact is, my application was there. I had retired in 2012 end, or since January 2013, effect was given. Then I realized, or rather our union realizes, that of the 72 employees who had applied at that time for this conversion around 2010, 67 were allowed. Only 5, including me, was not allowed. Now, who are these 5? These are those 5 employees who had retired in between August 2010, when the memorandum came in, and 31st December 2012, when it was given effect to. The other 65 were allowed, 67 were allowed, they had retired post 31st December 2012. So, these 5 only were left. 3 of whom, including this petitioner, are before your lordship, or I am representing rather. This is, my lord, in nutshell, is the dispute. Now, in their opposition, 2 things, I would say, my lord, my case is really, classically speaking, 2 things. Arbitrariness, discrimination. The ground of discrimination is that there is no reason why these 5 should not be allowed if those 67 have been allowed. Just because lordship knows there are authorities on this, that they cannot discriminate on the basis of date of retirement. This cutoff date, which is not there anywhere, this cannot be done. Second, what is most important is, they also say, 2 things they say. First, they say, as far as the import of that memorandum is concerned, they say, no, simplicity, I will show, my lord. They do not even consider the second limb. There, in opposition, the stance is that only those who could show that they had in fact applied in 1997, though they were eligible to be considered under the 2010 memorandum. Completely ignoring the second part of the memorandum. This is not a submission on the bar. I will take my other from records. The second part also, so this is one limb of my, should be my attack. The second limb is, they say, the wording is very curious. So I have annexed that register, copy of that register page. I have already told my lord. They say, they do not deny that this is fabricated. They do not say, I deny this document, nothing of that sort. They say, From the records, we find that even in 2010, nothing was submitted.
The copy of register indicates, according to you, submission of application from CPF to GPF in the year 1997.
2010.
Okay.
2010. 97, as I said, my lord, at the outset, I submitted.
No, that I understood.
I cannot show that.
Then in the event, for the sake of argument, if I accept your contention that you have really accepted, you have really applied for conversion from CPF to GPF in the year 2010, how do you justify your position? Because they say that in their memorandum that this will take effect post December 31st December 2012.
No, it does not say so. That is, their action says so, but the memorandum did not say so.
Oh, memorandum does not say so.
Memorandum does not say so. So I say you are discriminating against me based on no reasonable classification, and you are completely, I would show from the opposition, their stance is not on based on, I am saying that because of the action, but their stance is.
So in that memorandum, the first clause was that those who have applied
back in
the year 1997, but could not show any document.
And also could show in document and could show document that they had so applied, their case would be considered.
And what is the second one?
Second one is anybody else.
But the memorandum does not indicate any cut-off date.
No, I bow down to my lord. No, it does not.
Very good. So
now, two more points, then I will, my lord, show the documents. Now, this is one part, my lord. Their opposition, their stance, I am no longer repeating myself, their stance simplicity is, as far as the interpretation memorandum is concerned, they completely completely ignore the second part. They simply say, 97, you cannot show any document, therefore you are, that's it. As far as the 2010 is concerned, in paragraph 9 of my writ petition, I refer to this register, this thing that they, dealing with paragraphs 8 and 9 of my writ petition in their opposition, they do not deny straightforward that this is a procured document or something of that sort, that this document does not exist. I say this is page of your register maintained. They do not annex any document.
Why the register has become relevant, sir?
Because they say that from the records we find that even in 2010, this was not received from you. No,
just now you said, sir, since you retired prior to December 12, 2012, your application will not be considered.
That's their stance. That is their stance on law. That is their stance on law, that because you, not 2012, may I, my lord, rephrase myself, may I, my lord? Three things. First is interpretation of the memorandum. According to me, memorandum considered, this is on the face of it, no, review jurisdiction is not required, that very. Now, two things the memorandum said. One said that those of you who had applied in 97 and could show proof that yes, you had applied in 97, their case was considered. For some admission.
You do not come on that.
I do not.
Very good. True. What is the second one?
Second one is anybody else. All other cases.
Very good. You applied?
I applied.
Then what happened?
Now their defense is.
Your register, according to you, register shows your application.
I applied.
Receipt of your application.
Yes.
Next, what happened?
Now their stance is, first, on the interpretation. In the interpretation of the memorandum, they completely deny the second link, the residuary thing.
Deny the receipt of the application.
This is one. Receipt of application they deny. And also they say, according to the memorandum, only those who had applied in 97 and could show proof, they are eligible under this.
Ignoring the second part. Understood.
That's what. And I add a third to this, This is not in their defense as such. This is not. But their actions should show that, in fact, they are discriminating between those who had retired before 31st December 2012, when the memorandum was given effect to, and like me, and those who had retired after this.
Here I am a question. Just you said, quote unquote, where it was given effect to, on and from when it was given effect to. Wherefrom we will get these words? Wherefrom will we import these words?
No, this, my lord, I tell my lord, now I bow down to the query. This, my lord, lordship would find I have stated in my reply. Reply, I have also an extra document showing this is my reply.
good. Place
My
the
learned
doc-
friend can say this is incorrect statement.
Very good. Place the document.
এটা তো আমাদের ডকুমেন্ট লাগিয়েছি। হ্যাঁ হ্যাঁ ঠিক আছে দেখাবো দাঁড়া ওটাই তো লাগিয়েছি দাঁড়া
Very good.
Yes, may I? Now first, may I, my lord, take my lord to that memorandum.
Annexed to the writ petition.
Annexed to the writ petition. Lordship would kindly straight away come to page 27 of the writ petition. Lordship would kindly straight away come to page 27.
Yes.
May I, my lord, please?
Please.
This is dated 19th August 2010. The undersigned is directed to convey that the Board of Directors at its 165th meeting held on so-and-so considered the status regarding changeover of employees from CPF and CRG to GPF cum pension cum gratuity scheme and decided that those faculty and staff members who join the institute before so-and-so and will be able to submit a proof of their having submitted option for changeover from CPF, CPG to GPF cum pension cum gratuity scheme and their cases have not been considered due to administrative lapses be examined on case-to-case basis and the conversion from CPF whatever to GPF be allowed. Now may I, my lord, press the second?
Yes.
It was further decided that the faculty and staff members who will not be in a position to submit any proof of their having opted for the same, their request for conversion may be brought to the board for review and decision. May I have the place once again?
Yes.
So, Lordship will correct me if I am wrong. The second paragraph takes into its ambit everyone else. No fetter. And Lordship would, as the apropos the query that fell from my lord, this does not talk about any date of implementation as such. Now, Lordship would kindly turn the page, page 28.
Yes.
Sir, I submitted the option form so-and-so for changeover from CPG to GPF on 31/7/97, but due to some unfortunate circumstances, the option was not exercised till now. Please find enclosed a copy of the same. I shall be grateful to you if you kindly consider my case sympathetically as per memo number so-and-so. Now, Lordship would kindly turn two more pages. Page 30. Lordship has found page 30. Actually, 30 is a legible copy.
Yes.
Page 30. At the bottom, Lordship would find Registrar IIT Kharagpur, letter from Purva Kumar Sengupta, EC number so and so. Then Lordship would also find there is a purchase section, account section dated so and so at the top, the topish portion.
Page number 30.
Yes, here.
It is a memo dated 28 July 2011.
No. No.
Page number 30. 30.
30. Or rather 29. This should be 29. Sorry, I have.
Say like that.
Yes, it's 29.
29 or 29 capital A?
Yes, 29A. 29A. I miss. Am I missing on that? 29A.
Yes.
Now, from the top of the page, Lordship would first find purchase section, then account section, dated 23/8/010.
Yes.
Then at the bottom, Lordship would find Registrar IIT Kharagpur, letter from Purva Kumar Sengupta, EC number so and so. Yes. Lordship has found that immediately before the last entry,
Hmm.
or bottommost entry. Now,
What is this page?
this I say is the copy of the relevant page of the register maintained in the office.
Receiving register.
Receiving register. Lordship would kindly turn to my averment at paragraph 9, page 8. Paragraph 9, page 8. Paragraph 9.
But it does not bear any signature. Be that as it
No,
may.
this is
Paragraph 8, sir.
paragraph 9, page 8. Paragraph 9, page 8. May I, my lord, place? Thereafter, by a letter dated so and so, the petitioner duly submitted the option form which was submitted by him in 1997. It was specifically contended in the said communication that despite submission of the option form in 1997, no response was given by the authorities. In such communication, once again, the petitioner had expressed his intention to opt for GPF scheme. The factum of submission of the said letter dated so and so will be evident from the endorsement made in the register. That should be registered. Anyway.
You don't have any receipted copy of the letter or any.
This is what all I have. The signatures, my lord.
No, you don't have any receipted copy of the letter or the forwarding letter of your immediate superior.
No, that we don't know.
Very good.
But what is significant is how they have dealt with it. Now, my lord, I say what do
matter of fact, it was in the right
No, sir. No, sir. Not now. I will hear you.
Now, what I say now, lordship, the queries what are of course I bow down to that. But what I say I make a specific statement that this is the register that is maintained. This is a copy I have made of that page. I have made that. Now.
But so far as page number 29, capital A is concerned,
lordship,
a letter from such and such, it does not bear any date. It does not bear any signature also.
This is the date. Now, my lord, there's the instruction that these are the dates. This is way this fashion.
Kindly see the purchase section, account section.
Account section, yes.
Purchase section. There are
Then
some
the
initials and
signatures,
date.
Then signatures are there, my lord. That
Initials and date.
Yes.
But against your letter,
yes,
there is neither any signature nor any date.
Now, this lordship would find that this initial date that is there.
Very good.
This is now in the opposition. What do they say? Lordship has seen my document on which I base my.
Understand? Come to the point.
Yes. Now the opposition. Yes. Now, before coming to the opposition, would be lordship's pleasure also, my lord, to consider page 32. Page 32 of the this writ petition.
Yes.
Now, page 32, lordship would find this letter is dated June 12, 2013 from our union. Now, lordship would find subject request for conversion from CPF to GPF. Respected sir, we are thankful to you for your initiation to allow 67 members from IIT employees for switching over from CPF to GPF scheme. This decision was taken by the Board of Governors in this 160th meeting held on 17/6/2010 and was implemented by the Institute with effect from the month of January 2013. During the period from 17/6/2010 to 31/12/2012, that is the date of 165th BOG meeting to date of implementation by IIT authorities, some employees who have retired from institute service as given below were not considered for award of such switchover. Now, 1, 2, 3 serial numbers are before your lordships today. Item serial number 3 refers to Pralay Kumar Sengupta,
Hmm.
the immediate petitioner before your lordship.
This letter has been issued by your association.
Association. The next page is my letter. Next page is my letter. In view of the above, we would like to request you to kindly
Give me a second, sir.
Yes.
Though no indication of any receipt of this.
I understand, sir. Wait for some time. Yes, sir. Page number, then page number?
32. 32. In view of the above, we would request you to kindly consider their case sympathetically so that they will also have the benefit and equal justice. Next page is my representation. Now, Lordship would kindly consider their opposition. Now, Lordship would straight away come to page 11. Page 11 of the opposition.
Yes.
ঠিক আছে আসছি দাঁড়ান 11 paragraph 14 just found. With reference to paragraph 8 of the petition, it is stated that in terms of the decision of the Board of Governors in its 165th meeting held on 17 June 2010, the respondent institute issued a memo dated 19th August 2010 being annexed report to the petition. The said memo dated 19th August 2010 stipulated for examination on case-to-case basis allowed only consideration for change from CPF to GPF scheme in respect to the employees having a proof of submission of option for change given earlier and such cases been not considered earlier due to administrative lapses. May I, my lord, read once again? The said memo dated 19th August 2010 stipulated for examination on case-to-case basis and allowed only consideration for change from CPF to GPF in respect to the employees having a proof of submission of option for change given earlier and such cases been not considered earlier due to the administrative lapses. This is the first limb. If Lordship kindly goes back to that memo. At page 27 of the petition. Okay. The statement in this affidavit, the contention in the affidavit, opposition, relates to the first limb. This is absolutely fine. What about the second limb? I ask myself. It was further decided that the faculty and staff members will not be in a position to submit any proof of their having opted for the same. Their request for conversion may be brought to the board. The entire purpose is defeated. My lord.
Give me a second.
Yes.
Yes. Then?
Yes. Now, may I, my lord, continue with the opposition? That paragraph 14 at page 11. Yes. It is further denied that on the basis of the office memo dated 19th August 2010, being annexure P4 to the petition, the petitioner had applied on 23rd August 2010, being annexure P5 to the petition for conversion with a copy of the purported option stated to have been submitted on 31st July 1997 as alleged or at all. And then, as a matter of fact, after careful examination of the records of the respondent institute, it revealed that no such option was submitted by the petitioner as purportedly claimed by him. Then, my lord, next paragraph, paragraph 15. With reference to paragraph 9 of the petition, it is reiterated that no such option for change as per the office order dated so and so submitted petitioner. Moreover, the petitioner submitted nomination so and so. So, as far as 2010 is concerned, their statement is in paragraph 14 of the opposition. Those two sentences is further denied that on the basis of the office memo dated 19th August 2010, being annexure P4 to the petition, the petitioner had applied on 23rd August 2010, being annexure P5 to the petition for conversion with a copy of the purported option from.
You are reading which portion?
This these last 4 lines of page 11 of the opposition. After administrative lapses.
You have placed that.
Yes, yes. I'm just so their statement as to my having one is on law, whether what is the ambit of the memorandum, that is something else. But as far as the fact that whether I have in fact my lord submitted on 2010, their statement are twofold. First, they deny that is submitted. Then they say, after examination of the records, it is revealed that no such option was submitted. That's all.
In the year 1997.
2010. আরে বাবা দাঁড়া না যেটা আছে সেটা একটু দাঁড়া page 11 bottom last 4 lines immediately after the words administrative lapses was found, it is further denied that on the basis of the office memo dated 19th August 2010, being annexure P4 to the petition, the petitioner had applied on 23rd August 2010, being annexure P5 to the petition for conversion with a copy of the purported option form so and so.
That is after publication of this memo, you have not applied.
That's their thing.
There is their extent.
Now, next sentence. As a matter of fact, after careful examination of the records of the respondent institute, revealed that no such option was submitted by the petitioner as purportedly claimed by him. I would show, my lord, this is evasive denial. This amounts to no denial. I have referred to a particular document. I have said this is your document.
Sir, yes. I probably have understood case.
Yes.
In the event, I consider the memo dated 1908. It has got 2 parts. First part says that those who have submitted but could not be considered due to administrative lapses, their case can be considered. That is, on condition they have to prove they have to file or they have to prove that they have submitted application. And the second part says that who will not be in a position to submit any proof. Having opted for the same, their request for conversion may be brought into the court. Now, your second stand is that after publication of this memo, you submitted an application. You submitted an application. And in support of your contention, apart from the unsigned register, what document do you have?
That is the only document.
Then
I would say, my lord, no, here, my lord, what is I don't know what is falling from.
First prove your case, thereafter I shall go to their denial.
Lordship. This because, my lord, because it's a writ petition, a lordship would kindly appreciate.
Yes.
Today, a statute.
Sir, you have to discharge your initial burden.
Lordship.
That burden is always with you.
Lordship. I bow down. I bow down. If I discharge my burden, then no not shifts.
Absolutely.
Lordship. Now,
I admitted that in the year 1997 you have applied for option, you don't possess any document.
I don't work, I cannot.
You say in the year 2010 you have again applied.
Lordship.
On the basis of the part 2.
Lordship.
You rely upon a photocopy of the register which is unsigned.
Lordship.
Even it does not reflect the letter of your data.
Yes, it does.
It does not reflect the date of your letter.
Yes.
It bears no signature.
Yes.
Apart from that document, what document you have? That it is that letter which has been received and it was not considered as per the second part of the memo. Thereafter, the question of discrimination will arise.
Lordship, I bow down to that. Now, Lordship would kindly consider this. May I, my Lord, just try to articulate how the way I want to proceed on this. I mean, this question, of course, have to test. A statute. I make a positive averment. Lord should kindly hear me out. I make a positive averment that I have submitted this document. Along with, I also annex a document, rely on a document that look here, this is how I have submitted. This is the only record that was given to me. I could make the record that this is the register is recorded. I have said this. There is no dispute in this, that this document I am showing, that this is the only record, this is the only modicum upon which in the register I had to sign, I had taken a copy of that. This is what I have said. Now, the question that has, my Lord, very rightly fallen from my Lord, that whether you have discharged the burden. Now, my Lord, Lordship will correct me if I am wrong. I have this, my Lord, is the discharge of burden. Now, they had to say, my Lord, this I am, now when I annex this document, they had to say that one, look here, in our register, this is not the procedure that in register such entries are made. This is not the thing. They could have said, they had to say that look here, for 23/8/2010, because Lordship has noted in the document, copy document, date of 23/8/2010, that on 23/8/2010, these are all the pages.
All these question arises
Yes.
when you place document
Yes.
to substantiate that you have discharged your initial part.
Lordship. Now, my Lord, I ask myself that if this is the procedure established, if this is the case I have made out, that
Sir, you are a responsible staff of a reputed institution.
Lordship.
You prayed for conversion twice.
Lordship.
You don't have any document to show.
Because I bow down. Because the first time I did not have this document, I realized this lacuna is there. That is why the best case, whatever I could now get, I could get. Now, my Lord, no statement, at least on affidavit, is there till now that this is the established.
Even with this document, page 29 is taken at its face value.
Yes.
It does not indicate that they have received your letter.
Now.
It does not bear the letter, the date of letter. It does not bear the signature and date. Can it be called that is a proof of submission of the document?
Now, Lordship would correct me if I am wrong. Lordship would correct me if I am wrong. What is the standard of documentation? That depends on the, my Lord, procedure that is established.
No, sir.
Now, is there any statement Lordship has found? I ask myself.
very bad
in
case.
the opposition. Lordship would kindly hear me out. Lordship would kindly hear me out.
What I will hear? You just show me one document.
This is
just means
Lordship.
you just show me one document that on the basis of this memo you make an application for conversion from CPF to GPF. You submit one document. This document is not at all convincing.
This
sir.
is, my Lord, Lordship would kindly consider. This I say that this is the procedure that is established. They do not say. In their affidavit, I asked myself, have they made out a case that this is not the procedure how documents are submitted? No such case has been made out. They could have, my Lord, sought to make out.
I got you.
They have accepted that they have received it. So instead of 3 petitions, may it be only this petition. Because in the next petition, they have said that yes, we have received it. Those bit of facts are different. Otherwise, it's all the same. 2010, everything is same. But that it's there in the opposition.
Admitted.
It's there in their opposition. It's in front of me.
You have admitted.
Lordship can see from the affidavit.
অদ্ভুত কোনো ট্যাগিং অর্ডার হলো না অথচ ট্যাগিং হয়ে গেল আর কোন দেখি পরেরটা কি আছে দেখি Have you admitted?
Paragraph 11, page 9 of their opposition. In the
What's your
matter of
number?
Tapan Kumar Guchait.
Paragraph 11, last portion, Lordship. No such option was submitted in establishment section as claimed.
Lordship would kindly see what is
Page 9 of my opposition, Lordship.
বার করুন দেখি
In 1997, Lordship.
ক্যানটা কেন দিচ্ছেন আমায় WPA
This is
Lordship, WPA, Lordship.
33773.
33773. W of 2014, Lordship.
Lordship is in the opposition.
Mr. Dadgupta, let me reach. I am not so fast like you, sir.
Lordship.
You have to bear a slow judge. What can be done?
No, not at all. Not at all. I was only a little.
Based on the above opposition.
Place.
Yes.
Place.
Lordship.
Place the relevant line.
Yes. The said memo dated 19th August 2010 stipulated for examination on case-to-case basis and allowed only consideration for change from CPF to DPF in respect to having a proof of submission of option for change given earlier, and such cases has not been considered earlier due to administrative lapses. Based on the above office memo, the petitioner applied on 24th August 2010 for conversion with a copy of the option submitted on 6th August 1997.
Then?
And after it revealed that no such option in 1997, no such option was submitted in the establishment section as claimed, which is clear from the next paragraph. Page 10, Lordship would kindly see. What was not available? There are two parts, my lord, to this statement. Third line from top. As such, submission of option as per of aforesaid office order dated 25th July 1997 is borne on the records of the responding institute. It is stated that the case of the petitioner is examined, but no administrative lapses were found with that person, thus the petitioner. So, again, my lord, if I go back to paragraph 11, first part.
As a submission of option as per
Yes.
office order dated is not born on the records.
Yes. So they are completely denying the next part of the memo. Lordship has recorded already in the order. Now, Lordship would kindly turn back.
Just a minute, sir.
Lordship.
No. My lord, your lordship. No administrative lapses were found with respect to the
What document you have annexed?
Yes, page 30 of the writ petition, page 30. Page 29 is the application, 30 is the
Page 30, which portion?
top two envelopes from TK Guchait and Rajkumar Malik. What else? I ask myself, my lord, I can. And now,
আসুন ওই যে প্রথমটা পড়েছি না লাইন অ্যাড করুন তো Seats.
yes.
It was the first one was dismissed in absence of any proof of submission of your
Yes,
application.
that's my lord's finding.
But in the second application, I understand your contention. There are proof of submission of document according to you, and they have considered your application on the basis of the first limb, but they have not considered the second limb. That is your case.
That difference
It will be taken care of.
only one more sentence, my lord. One more sentence. In both this
Well,
one,
they have not mentioned any of the thing.
Only item number 31 is dismissed. Item number 32 and 33 will remain.
In 33, lords, there is no such document with regard to item number
I shall pass separate orders. Either in his favor or in your favor. But I will pass separate orders.
Yes.
Sir, there must be a method in madness. There is no order of tagging. At least you cannot sue, nor I can see. And I think that the cases are not identical. So separate orders are required to be passed. Why? For one person, the other persons will be deprived if they have a good genuine case. চল এই কালকে এইটাও থাকবে as if কালকে ওটা শো করবে it will remain tomorrow as it is only 31 days শোনো একটা লাইন অ্যাড করে দিন SEO is directed to
Cautious. Able to assist your lordship in this. No, I completely, I can. In fact, it's not really my place to point out. Few previous orders suffer from exactly this. I was visiting. Can it may it be on Tuesday, subject to lordship's pleasure? 32 and 33. Tuesday, because Monday is the monthly list. I do not want that. Tuesday 2 p.m. Or it may remain tomorrow as my lord pleases. Maybe Tuesday would have been a little bit more convenient to me. But no, let it remain. Let it remain. Let it remain. Lordship.
Yes, affidavit in reply, all are necessary. I have submitted only in respect of my lord 20A record of rights in the name of Prafullo Kumari Datta. And my lord 21A, here the attestation date was 10th December 1968. the everything they are similar. ভারত সম্রাটের পক্ষে 24 পরগনা কালেক্টর প্রফুল্ল কুমারী দত্ত. Attestation was in 20A 10th December 1968, and now my lord in 21A same record of rights, similar, but the date is different. Here 10th December 83. If your lordship kindly sees, my lord, the date of attestation. December 1968.
And
Now, my lord,
2010 December 1983.
83 and 22A again 10 December 68. The 22A.
Yes.
Now, my lord, kindly come paragraph 1 of the writ petition.
Yes.
Your petitioner is a citizen of India, is related to pro forma respondent through the common relation Prafullo Kumari Dotto, who died. My lord, I am impressing this order, died. Tested or intested, nothing has been mentioned. Died. Possessed several properties, including the land being at measuring 120 cutters, be the same or little or more or less, situated at District 24 Parganas South, PS Kosba, jail number 13, Mauja Kosba, comprise Dag number 3775, 3777, 3788. And a genealogical table has been annexed. Well, kindly come the genealogical table at page 19.
Yes.
Prafullo Kumari Dotto died much prior to coming into force of the West Bengal State Acquisition Act. First sentence, died on 7th February 1950. According to their genealogical table, he had 4 sons.
Subodh, Sushil, Sunil, Sudhir.
Yes. Subodh, predeceased, unmarried. Sushil died, it is also predeceased, 22nd December 1936. Meera Dotto died 1949. Both are predeceased. Sunil Dotto, predeceased, unmarried. Sudhir Kumar Dotto died on 16 December 1979. Binapani Dotto, such and such. Now, from Sushil Dotto, the genealogical table is there. Shankar Dotto, in the left hand column, he has 4 daughters. Pratima Bose, Gita Bose, Lokhi Mitra, Ratna Mitra. Shankar died in 1994. Supriya Dotto. Supriya Dotto is one of the petitioners.
Supriya Dotto is one of the petitioners.
My lord, Supriya Dotto is the petitioner. He is the only sole petitioner.
Achha. Yes.
Now, my lord, in thereafter, my lord, Ruby Ghosh, Isules, Sajal Dotto died. Sumitra Dotto. Sumitra Dotto, he is the, my lord, the pro forma respondent. And my lord, the in the left hand column, Santanu Dotto, Madhurima Dotto, Madhumita Bose. Now, how the property has been devolved, how they have become owner, there is not a single averment. Prafullo Kumari Dotto, how the property has been devolved, and no record of rights in respect of the name of the petitioner. He is claiming in the year 31. 31, to whom it is to be served?
31.
31 of the
Act 1948.
48. To whom it is to be served? First of all, he must be some document, some records In the sky, there cannot be any law. And my lord, very interestingly, my lord, paragraph 2 has been started.
Yes.
And after Profullo, no record of rights. And Profullo expired in 1950, much prior to coming into force of the West Bengal State Acquisition Act. And the date of vesting under the West Bengal State Acquisition Act, the intermediary 15th April 1954 and riot 14th April 1956. And arrest record must reflect who is on the date of possession. Now, my lord, paragraph 2, I am placing the paragraph 2. The said land until recently was an open plot of land which made it difficult, if not possible, to locate and identify the exact situation thereof. He is claiming that he has not been served with the notice. 3.1. And law in respect of 3.1. The ownership of the said land was absolutely vested to Profullo Kumari Dotto hereinafter the said deceased who died in 7th February 1950. Now, how the Profullo Kumari Devi got the property, there is no such averment. How the, my lord, she had, according to the genealogy table, that is not also the part of averment or affidavit. It is genealogical table. And my lord, very interestingly, my lord, it is a technical point, but I will take it in this case. Kindly come page 18, the affidavit. I, Supriya Dotto, wife of Shankar Chandra Dotto, Hindu businessman residing such and such, do hereby solemnly affirm. No age, whether it is affidavit or whether any, it can be termed as an affidavit.
Very good.
My lord, in this regard, my lord, there is a Supreme Court cases relating to the Panchayat election. My lord, the affidavit, if it is blank, it is nugatory. My lord, affidavit must be with the rules.
So far as the pleadings are concerned,
my lord,
in read petition,
my lord,
is there any averment as to how Profullo Kumari Dotto became the owner?
No.
And as to how the read petitioner inherited the property?
No such averment. Profullo Dotto.
Such absolute ownership would clearly appear from the concerned record of rights.
Record of rights. The record of rights, my lord, I have said, my lord, I have pointed out, this record of rights is neither CS nor RS nor LR.
Then what is this?
Kindly see, my lord, kindly see Bharat Samrater Pokkhe. My lord, see, kindly see. And I have annexed another RS record of rights to whom I have given the awarded money. I will come to my affidavit in opposition later on. Bharat Samrater Pokkhe, it can be only in the CS record of rights.
So this is also CS, no?
No. Attestation is 68. How it can be CS? CS, my lord, after final publication made in 1935. RS operation come into play in, my lord, after 1955. Well, that is why I am pointing out.
Very good. Then
And my lord, here in this case, such absolute ownership would clearly appear in the concerned record of right published in here. Only 83 has been mentioned, not 68, though they have annexed two others record of rights. In paragraph 2, it has been mentioned only 1983. And 83, my lord, Land Reforms Act has come into operation. Chapter 2B came into operation from afterwards 1975. The rightful claim of the petitioner and proponent respondent in respect of the paragraph 3 mentioned in paragraph 2 has never been disputed at any point of time. In fact, as stated, aforesaid various properties belong to the said deceased became vested in the petitioner and proponent respondent and their predecessor in interest. All steps in connection with the receiving compensations were paid with regard to thereto have been received by the petitioner and pro forma respondent along with others. The copy of the notice of award in the name of the son of the petitioner is annexed here too at marked with, but the son of the petitioner is the owner in respect of different plot, and he has been given compensation. And the son of the petitioner, according to the genealogical table, he is also owner, but he is not in the petitioner. Only the widow has come.
So what do you want to say then?
Section 3 notice.
You are challenging the locus standi of the petitioner?
Yes, I am challenging the locus standi of the petitioner. And I have said in my affidavit in opposition that this record of rights does not match with the original arrest record of rights. And we have issued section 4A and we have also issued 301 also, but not to the petitioner. But that has not been annexed, but I have got.
Show me the relevant portion.
My lord.
Show me the relevant portion of your affidavit in opposition.
My lord, in my affidavit in opposition, my lord. My lord, I am placing paragraph 6, my lord, learned friend has also played. The writ petitioner pledge for withdraw, rescind or
para, sir?
My lord, paragraph 6A.
Yes.
The writ petitioner pledge for withdraw, rescind or set aside the entire dealing, including the license deed made between KMDA and Haldiram Limited, as well as further pledge for declaration that there has been no acquisition proceeding of such and such. RS plot number such and such again plots were acquisition by the competent
we are now concerned with the 3777.
My lord?
We are now concerned with
three plots. All the 3 plots. Plots.
No. Subject matter of the dispute in the eastern writ petition is 3777.
No, all the 3775.
Yes.
3777.
Yes. Paragraph 1.
Yes. All these 3 plots for the purpose of construction of EM bypass by the requiring body KMDA for such acquisition and requiring body the CMDA known such and such photocopy of the certificate of possession. I have given the certificate of possession.
No, you told me that you have annexed the RS record.
Yes, my lord. I have annexed the RS record.
Show me that portion.
Yes. Kindly come, my lord, page 16.
16.
To whom I have given the compensation money.
It is in respect of which plot? Dark number?
My lord, all the 3 plots are. Kindly come, my lord, next page. Page 17, 3777. Then, my lord, come page number 19, 3788.
3788. Yes.
And my lord, the last one is 22. That is 3775.
3775.
Those are the challenge, my lord. 3775, 3777, 3788. And my lord, if your lordship kindly come,
Give me a second, sir.
page 26 the award. 26, my lord, in the
Sir, wait. Let me note, sir. There is no use of continuing argument if I cannot note.
Yes, my lord. The paragraph 8 do not match.
So, Mr. Mahata,
my lord,
I believe it would be your contention that page number 16 to 25
my lord,
are the correct RSROR according to you,
my lord.
showing the recording of names of the riots, which are, however, different from page 20A, 21A, and 22A of the writ petition, which the writ petitioner has placed his reliance by saying correct RSROR.
My lord.
And according to you, those are not the correct record of right.
Right.
Neither CSROR nor RSROR or LRROR.
My lord.
That is your case.
My lord.
Very good. Next.
My lord, in paragraph 8, my lord, I have, my lord, my lord, I have in my opposition, my lord, I have stated that section 4 publication of section 4 notification, my lord, that is in paragraph 6B, certificate of possession, and 6C, my lord, is a notice under section 4A.
Mr. Mahata, give me a second.
My lord. In my opposition section, paragraph 6B is the certificate of possession, and possession comes surely after issuance of section 3(1). And unless 3(1) is issued, possession cannot be taken. My lord, though I have not annexed, but I have got the notification of section 3(1).
You have not filed it.
My lord?
Why you have not filed it then?
My lord, it was prepared yesterday. The officer came and I want to bring those 3(1). He has brought today.
So file it.
My lord, I can file it.
Very good. Continue argument, file it tomorrow.
Yes.
By way of supplementary affidavit.
अच्छा की officer. आपने के लिए ले चुके. My lord, kindly, my lord, paragraph B, my lord, I have stated that RS plots number such and such or Moja such and such were acquisition by the competent authority by the LA case number such and such.
You are referring which portion, sir?
My lord, my affidavit in opposition 6B.
6B.
My lord.
Yes. Please.
RS plots number, those 3 plots, along with several other plots under Mauja Kosba, JL number 13, were acquisition by the competent authority by LA case number such and such for the purpose of construction of EM bypass by the requiring body KMDA. For such acquisition, the required body being the CMDA, now KMDA, has handed over the entire area, including the present plots, land on 18 December 1973. Photocopy, Malada, kindly come, Malad, the possession certificate I have given. What is, Malad? It is at page 12. And the plots has been mentioned in page 13.
Mr. Mahata, I will look to that on later on. So, when you are challenging, you are challenging the correctness of the record of right. What is your averment in your affidavit? There is no such averment.
The averment is there. Maloda, kindly come, Maloda, paragraph 8.
Yes.
With reference to the statement made in paragraph number 2 and 3 of the said petition, I deny and dispute each and every allegation 7 except what are matters of record, and I have stated in paragraph 5 are reiterated. I said that the claim of the petitioner to locate and identify situation of the land of the petitioner does not and cannot arise since the lands have already been acquired, possession handed over to, and award declared and paid compensation. The Khotian number as annexed in the writ petition do not match with the present record of rights supplied by the BLLR Kolkata for proper compensation paid to the owners of the land. Do not match. I have not alleged that it is fraud, because fraud is, actually, the latest decision of the Supreme Court, fraud is to be declared by the court. I have said do not match.
So, Mr. Mahata,
and
I'm asking a question to you.
My lord.
In the writ petition, the writ petitioner claimed his right, title, and interest if there be any over the property in question over the 3 plots of land, probably by way of succession, may be tested or intested from Prafullo Kumar.
Prafullo Kumari.
You say that the record of right in respect of these said 3 plots as have been annexed with the writ petition do not match with the record of right as maintained in the office of the government. And you are also challenging the locus standi of the writ petitioner.
My lord.
Since no document of title has been placed on behalf of the writ petitioner over the said 3 plots of land.
And another most important thing, my lord, if your lordship, my learned friend, has relied upon in the affidavit in reply, kindly come, my lord, the document.
Affidavit in reply against your affidavit in opposition?
Yes, against my affidavit in opposition.
Yes.
And that is at page 14. My learned friend is very cleverly skip this thing.
Yes,
page 14.
Yes.
Whereas it has been brought to my notice that finally published Khotian's number such and such of Mauja such and such of Kosba has been incorrectly made and has been illegally and or fraudulently tampered with.
So, where from you are reading, sir?
Well, the first paragraph,
Page 14.
17th March.
Page 14.
Page 14 of the affidavit in reply, the documents, the order, certified copy.
Yes, kindly place, sir.
whereas it has been brought to my notice that finally published Khotian's number such and such of Mauja Kosba jail number PS Kosba has been incorrectly made, stroke has been illegally and or fraudulently tampered with. And my lord, he has relied upon page 24.
Tampered with as vitiated, and whereas it is considered necessary to examine record and connected papers.
Yes,
It is
and-
ordered the DA to put up the ROR and papers for my examination and such as.
Everything has been done, my lord. If my lord, material part is, my lord, page 24.
Yes.
24.
Yes.
My lord, kindly see the Khotian number.
Give me-
1152,
give me
834.
a second. Hey, flat page. Page number 24, you said, no?
Page number 24.
Yes.
My lord, these plots have been mentioned, name Prafullo Kumar Dutta in right hand at the top. My lord, the three plots, do. Then my lord, Prafullo K.R. Dotto. We may assume at that Prafullo Kumari Dotto. We may assume. And now the my lord, kindly see.
What are the plot numbers?
My lord, these Khotians have been given. Those are
Khotian numbers.
kindly see the Khotians now.
Yes.
Kindly see the Khotians, which has been annexed by the writ petitioner. My lord, kindly come. Page 28, 689.
Page 28.
Page 28. Khotian number.
28. Acha.
Khotian number 689.
689.
And then my lord, 21A, 1102. 11? Oh, sorry, my lord. I missed it, 1152.
52, yes. And 834.
And my lord, 834.
Yes.
These have been mentioned. And my lord, kindly see the few last, my lord, after that, from the following Xerox copies of the information, it reveals that Otindranath Das and others were the superior landlords but failed to produce the corresponding RS Khotians. And this is not my document. My learned friend is relying upon. I have not relied upon.
What do you want to say by saying this?
I think my lord, these documents are the my lord, fraudulent. These are not correct documents.
28, 20B and 20.
My lord. These Khotians.
From the following Xerox copies of the information as it reveals that Otindra Dotto and others were the superior landlord failed to produce the corresponding. Mr. Mahara, I am not clear. Still, I am not clear.
My lord, these proceeding has been initiated to detect the fraudulent tampering records.
Very good.
These plots are mentioned there.
Yes.
And my lord, the findings is that the original records could not be produced from those records.
Who are Otindro then?
Otindranath Das, my lord, Otindranath Das is the original the Jamindar. My lord, Prafullo Kumari Devi has not, in the description, there is no averment from which, whether it is inheritable property or it is by way of purchase, there is no such averment. How did she become the owner? There is no averment. Though no averment. And the my lord reply of my paragraph 6A to 6E and 7 and 9, kindly see only mere denial. There is no specific case made out. And another thing, my lord, it is very surprising, my lord, to point out, if your lordship kindly come, page 29 of the writ petition.
Yes.
My lord, information was supplied, my lord, kindly see the right hand column. It appears from the available records of this office that CS Dax number such and such. My lord, here it is clearly mentioned CS. Here there is no mentioning of RS. So 6883 cannot. CS, here it is mentioning about CS. So attested in 68 or 83 cannot and does not arise. CS record cannot be attested in 68 or 83. Here it is clearly mentioned CS. Now, my lord, kindly see, of Mauja have not been affected by any LA proceeding of office from 1984 to 16/5/1995. Who has issued this information? Superintendent LA office. Is there any post superintendent? Under the land acquisition department, my lord knows very much experience with this collector, special land acquisition officer, land acquisition officer. Superintendent, is there any post?
In the office of the land acquisition, there is no post of superintendent.
No. Collector, district magistrate and collector. Then, my lord, special land acquisition officer, land acquisition officer. No superintendent.
Superintendent means Boro Babu. There is a who has the.
No. There is no such post in respect of the land acquisition. No hierarchy.
Every government office there is a post of superintendent.
My lord, but in the land acquisition post, there is no such post of superintendent. And information is to be supplied by the either by the special land acquisition officer. My lord is dealing with every day and every time. Every information is being supplied by the special land acquisition officer or the special land acquisition officer or the land acquisition collector. Now, my lord, if your lordship kindly come, page 28A. Admittedly,
Give me a second. Yes, page number
28A,
28, capital A.
small a.
Small a. Yes.
To my lord address Prafullo Kumari Dotto. When 6/3/1999 and she expired according to paragraph 1 and 2 1950 and the genealogical table also 1950 and they are relying this document. Application for no objection certificate in respect of the premises.
On the basis of the letter alleged to be written by Prafullo Kumar Datta.
My lord.
Application for no objection
yes
has been made by Prafullo Kumari Datta. Pursuant to that letter, this no letter was issued.
My lord. Yes.
I am directed to refer to a letter number such as 9/1/1997.
Yes.
9/1/1997. Prafullo Kumari died.
Prafullo Kumari died in my lord 1950.
Then how is in 1997 she can write a letter?
My lord, that is the my lord, that is the my lord is to my lord consider that. Then it is admission paragraph 1 genealogical table and everything that Prafullo Kumari Datta died in 1950. And this has been relied upon in the writ petition. High prerogative writ petition.
Yes.
My lord, page number 27.
Yes.
Already it is also addressed to the Prafullo Kumari Datta. Date is 2nd September 1996.
Nineteen 1996 it should be.
96, yes. It is in 2nd September 1996. Demarcation addressed to Prafullo Kumari Datta, who expired in
78. I will submit, Lord, I will make it.
Yes.
My lord, in my affidavit in opposition, my lord, I have specifically stated in some paragraphs. If your lordship kindly come, paragraph 9.
Para 9.
Paragraph
Page
9.
Paragraph 9.
Paragraph 9, page 7.
Para 9. Yes.
With reference to the statement made in paragraph number 4 and 5 of the writ petition, I deny and dispute each and every allegation, save and except what are matters of record, and what I have stated in paragraph 5 are reiterated. I say that since the land has been acquired and possession has already been handed over to the CMD, proper compensation has been paid at this stage. The pro forma respondent having no legal right to claim as the owner of the said land. I further said that the acquisition of the aforesaid land is full and final. Long back in the year 1976, CMDA has taken possession thereof. Compensation has been paid to the awardee. Therefore, the communication dated 22nd November 2007 claim to be furnished by the public information officer being the deputy secretary KMDSL have no legally valid at all. What is, my lord? They have got another document of 22nd November 2007.
Where is that document?
My lord, that is page 36 of the writ petition.
Communication dated 22/11/2007.
My lord.
But the page number 36 is the 16/11/2007.
My lord. 14th/11, my lord, kindly see the signature.
Huh?
The 16th/11. 16th/11. 15th.
Yeah, another letter. No, sir. Its side is not clear.
Not 27.
No. Therefore, the communication dated 22/11/2007 claimed to be furnished by public information. Where is that?
35, my lord. 35. Not 35. It is 35. আমারটা উল্টো দিকে দিয়ে আছে ওই জন্য আমারটা উল্টো হয়ে আছে আগে 36 আছে তারপর
Please find a copy of the ATO. So this is the forwarding letter.
Forwarding letter.
So page number 36. So page number 36 indicates acquisition.
Yes.
So what is the infirmity?
My lord, that is the acquisition.
Oh, I say kindly come to paragraph 9.
My lord.
Since the land has been acquired and possession has already been handed over to the CMDA and proper compensation has been paid at this stage, the pro forma respondents having no legal right to claim as the owner of the suit land.
My lord.
I further said that the acquisition of the aforesaid land is full and final long back in the year 1976 and CMDA taken possession on such and such and compensation has been paid to the awardees. Therefore, the communication rate claimed to be furnished by PIO, being the deputy secretary having no legality and validity at all. In reference to the memo, sir, information as regards the aforesaid RS Dak number are as such, the RS Dak number such has been acquired fully by KMDA in LA case number such and such of 73 for the purpose of improvement. So where is the wrong in it, sir? কি বলছেন উনি?
20 second.
2211 is a forwarding letter enclosing therewith the letter dated 16/11/2007.
There is no wrong.
Then?
This part has no relevance. This part has no relevance. লিখেছে এরকম মুশকিল।
Any other point?
My lord, first, my lord, I want to, my lord, relating to the affidavit, today I will submit only one judgment. That is the affidavit. The age has not been.
Mr. Mara, let me summarize. I believe it is your first contention that the record of right as placed before this court along with the writ petition according to you do not match with the record of right as maintained in the office of the
BLLR.
It is your first contention. Second contention is that the writ petitioner has failed to prove his local standard to file and maintain the instant writ petition in absence of any cogent document of ownership. Third, it is your third contention that there is no specific pleading in the instant writ petition as to how the writ petitioner got right, title, and interest over the 3 plots of land by way of inheritance. Even the genealogical table do not indicate whether by way of tested success or intested success. And Mr. Mahata, it is also your contention that the record of right which have been relied upon by the writ petitioner in their writ petition cannot be attested at such a later stage. These are your main content.
These are my main contention. And my lord, in respect of the my lord, relating to the my lord the submission, the 3-1 mandatory. I am also admitting mandatory. The decision relied upon by my learned friend. 3-1 must be there. Without 3-1, 4A cannot. And my lord, if your lordship kindly come,
no sir, that becomes relevant only if this court finds that sufficient cogent materials
materials have been given their title and ownership
to substantiate that he being the owner of the Prabhulla, he being the successor of the Prabhulla Kumari, or the Prabhulla Kumari was the real owner. Then those questions will be considered.
Then those questions will be considered. Then those questions will be sufficient. And my lord, and in the writ petition, there is no averment of the submissions which have been.
Very good. I want to see tomorrow the section 3 notice.
Section 3 notice, my lord, I have got just now. I can hand over today, my lord. But it is not in affidavit.
Very good. Give it to me.
Yes.
This is not a civil court. This is a writ court.
This is writ court, my lord. My lord.
My power is.
My lord. Just now, my lord.
Lord is absolutely correct. Whether 3-1 notice, they are entitled to.
My lord, this is.
Local standard has to be proved.
My lord, this is the notice under 3-1.
May I get a copy of
it? Yes. 3-1. Yeah.
Plot numbers are there.
3788, my lord, I find here.
3788,
the last plot. My lord, there must be others.
No. 3788 is there.
Yes.
3777 is also
3777 is
there.
there. 3775 is there.
And
all are here.
3775.
Yes, all are here.
সেটা আবার কোথায় রে? Yes, yes,
After 375, there 378, and last one
yes.
378.
একবার এটা দেখাও তো, বিলংকে।
Yes,
Whether I have correctly marked it or kindly check, sir.
yes, my lord. Correctly marked.
Mr. Mahara.
Of record, my lord, late Sama Prasanna Rai Chaudhary, my senior Mr. Gauri Dev was junior to him. And when he said, first of all, I am the junior. LCR has come, go and check through or everything and give me the note. LCR has come. Now check everything and take note of 3 pages and give me by today. My lord. My lord. My lord.
Reply, I will.
ঠিক আছে
Let this be on affidavit.
I shall consider that.
My lord.
Give it.
Yeah, my lord. This is, my lord, very short judgment in respect of the affidavit. My lord, this is, my lord, 2014 SCC page 189. 2014 SCC page 189, paragraph 20C Roman 3. 27.
I'm sorry.
Roman 3.
27.
Filing of affidavit with blank particulars will render the affidavit nugatory. My lord, only one line I will show. My lord, this is the case in respect of the filing of nomination in Panchayat. My lord, now I have been given some cases to deal with the Panchayat, my lord. Then I have to only my lord, one sentence. And my lord, tomorrow I will cite, my lord, on that, my lord, that is that if the averments and prayers are not there, requirement of rules.
এইটা লেখা হচ্ছে রেসপন্ডেন্ট স্টেট বলে লেখো রেসপন্ডেন্ট অবলিক স্টেট টেক ডাউন Tomorrow it was already fixed. And I'll pass it another on that day also.
You will cite other judgments also.
Another, I will cite
Tomorrow
a-
is the date, 3 p.m.
Praying for 29.
No,
No, for filing supplementary affidavit on the day after.
29th, but I will submit one judgment. It will take maximum 10 minutes.
No, sir. 3 p.m. tomorrow.
Your Lordship, I do not want to disturb this court, but this is quite urgent, Your Lordship.
Everybody has urgency
Your
for
Lordship, my client is going to be evicted by tomorrow, 2 p.m., 12 o'clock, Your Lordship.
By which authority?
BLR, Your Lordship. Your Lordship has granted the leave fixed today.
Let them evict. I shall consider that. He must be an encroacher.
No, definitely not, Your Lordship. There is the cause of action arose in the
In a 10-3 proceeding.
What, Your Lordship?
In which proceeding they are going to evict you?
There is no proceeding, Your Lordship. In advertent order, letter, Your Lordship. Your Lordship has considered the urgency, fixed the matter today. Somehow the matter was not heard.
Which one?
Item number 9, Your Lordship.
We will take it up tomorrow.
Lordship, I have been informed by the court officer that Your Lordship has directed him to keep the matter combined list, Your Lordship. Matters will be taken up. My entire writ petition will infructuous, Your Lordship. In this stage, Your Lordship, hardly we get briefs, Your Lordship.
আইটেম নাম্বার 9 তো আগামীকালই থাকবে। আমরা তো আজকে কত অবধি করেছি?
8। Your Lordship, by 12 they are going to evict me. If at the first sitting of the court, it will be considered. Subrata Datta, Your Lordship. Grateful, Your Lordship. Grateful, Your Lordship.